Testing.
I'm the mic.
Nice. Is this one on? Yes, cheers.
Are we good to go?
Good to go. You're good to go?
Everything's good. Yep.
We're good.
Good.
All right.
Right.
Peter, I'm going to keep you unmuted.
Hello, everyone. I think it's about 12:30. We'll get going. Welcome, everyone. This is a very good turnout we're having. My name is Gabriel Stern. I'm the chair of the TCLG, the Toronto Computer Lawyers Group, one of the three organizations which are have co-organized this today: TCLG, iTech Law, and CanTech. So we're very excited to be working together. Very happy to see this turnout. This is at least the second year we've been doing this together, possibly the third. Again, there's a degree of overlap between membership and the organizations, but it's great to see so many people come out to see this. Just a quick introduction on our speaker for those of you who don't know him. Peter Ruby, to my left. He's a leading IT litigator, well known within the technology law community in Canada, both Canada and internationally. He's been counsel in key software and internet cases. He also teaches internet law at U of T in Osgood and has done so for over a decade. This talk, as I said, we've been doing for a few years now. It's ended up being very popular. For today, we have, I think, over 325 folks registered, including a large number who are currently participating on the webcast. So welcome to everyone who's not physically here, but is tuning in. Peter, as he goes through his talk, he'll be welcoming questions as he goes. There's a microphone which will be floating around, so no need to hold your questions until the end of the talk. If he says something interesting, you have a question, feel free to ask it. But just please raise your hand to get the microphone. For those of you watching by webinar, there is a chat feature on your screen that allows you to send in questions. Given the number of folks who have logged in, handling of the web questions may be tough, but we will do our best to address those. So thank you very much, and then over to Peter.
Thanks very much, Gabriel. I really appreciate all the three organizations working together. I can tell you that I'm a member of all three, and I get quite different but very valuable things about participation in each of them, including going to the different events TCLG, iTech Law, and CanTech put on through the year. So let's dive in. Now, like many of you, I spend some of my time dealing with cutting edge or bleeding edge technology issues, dealing with things like artificial intelligence. But the 5 topics that we're going to cover today that are on your screen are really bread and butter issues. And the reason we're doing these is because while we in this room and on the web spend some of our time on the AI mountaintops, we really spend most of our time in the valley responding to business questions that involve the bread and butter topics like we're going to cover today. And I should tell you, all these subjects were chosen not from a theoretical point of view, but these are all things that we get asked about quite regularly, either by in-house counsel or by non-Canadian lawyers who are doing business with Canadians or in Canada. I will tell you that some of these topics are very broad. I promise I am not going to do a comprehensive review of everything there is to know, for example, about arbitration. That's not the role today. I'm just going to try and pick out a few bits that I think are interesting and hopefully you do too. Now, as really a housekeeping thing, everybody, whether you're here in person in Toronto or you're on the web, we're going to send out after today a list of all the cases together with hyperlinks and citations. You'll also be able to download the slides, so maybe that'll help a little bit if you want to take the odd note. You don't have to try and copy down every name of every case that we're going to cover. And we'll also send you at the end information for how to get that all-important CPD credit for today. But most importantly, being here, particularly with the people who are in the room, I did a seminar like this about cybersecurity not that long ago. And, the organization we did it with had these feedback cards. And the one comment I remember came back was, we love the videos, but, quote, there should have been cookies on the table. Okay, so I was sitting at a family dinner and I told a story about what I thought was a funny comment somebody had made. And my mother looked at me dead serious and said, "You should have had cookies on the table." So if any of you bump into my mother, can you please let her know that this time we provided cookies? All right. So let's start with the first topic, which is limitation of liability and indemnity clauses. Everyone will know that these are often the subject of extensive negotiation, and when a deal goes sour, they're often one of the first things that everybody looks at to determine rights. And just to keep things interesting, instead of sort of reviewing the law in a straightforward sort of academic way, let's look at this from the point of view of how people avoid limitation of liability clauses. So some techniques for getting out of them. And I'm going to deal with 4 techniques. The first one I'll tell you right up front is now defunct, but we keep getting questions about it, so I'll cover it off. And they're the 4 items on your screen, and we'll go through them one at a time. Starting with fundamental breach. This used to be the #1 way of getting out of a limitation of liability clause, and we still get asked about it all the time. And the idea is if there's been a fundamental breach by a wrongdoer, then the innocent party could avoid the application or cap on liability from a limitation of liability clause. So that would be a fundamental breach. The courts have used all kinds of words over time for how bad a breach it had to be, not a regular breach, something fundamental. But 9 years ago, this doctrine was stabbed through the heart. I'm still mentioning it because in other jurisdictions around the world, maybe using different words, including the United States, they seem to have a similar concept, a fundamental breach that still exists. So it's worth looking at so we can talk about it and explain the difference to Canadian law when we're dealing, in this instance, I'm thinking of our US colleagues. But I would like to show you and take a minute to show you the dagger the Supreme Court of Canada used to kill this doctrine. So that dagger was in a case called Turcon. My guess is almost everybody is familiar with it, so I'm going to deal with the facts very quickly. This is a case in a lot of ways that's important to people in commercial practice. And Turcon arose in an RFP situation. The BC government issued an RFP to design and build a highway. Then it decided it didn't want to have, as part of the RFP, the design component. So it issued a second RFP just to build the highway. And it had an express condition in that second RFP that only bidders who had qualified under the first RFP could bid and were qualified to bid under the second RFP, which is the one that went ahead. At the end of the day, though, the BC government chose what was effectively a joint venture between a qualified bidder and an unqualified bidder, somebody who hadn't participated in the first round. And one of the bidders, what we sometimes call a bidder, who hadn't won, sued the government and said, well, that's not fair. You didn't follow your own process. This unqualified person shouldn't have been allowed to participate. The problem for the bidder who was upset and sued was that there was a limitation of liability clause, or one of the problems, in the RFP contract. So the way they tried to get around it is they said, well, allowing a non-qualified bidder to bid is a fundamental breach, and so the limitation of liability clause should not be applied. And it's worth looking at the words of the limitation of liability clause that were present in that particular case. Now, I'm not going to read it to you. Everybody can read it on the screen at the office, home, or in the room. But you'll recognize that this is not, it's not a lot of language, not a lot of words for what was going to stop a very large lawsuit. Now, the trial judge who heard this case said this clause that you see on the screen was ambiguous and resolved the ambiguity in favor of the claimant, that is, the bidder that was upset, and ordered compensation for that bidder. The BC Court of Appeal reversed that decision and said the clause was unambiguous and barred compensation to the claimant. This went to the Supreme Court of Canada, who came up with an analytical framework that we'll talk a little bit about. But let me pause here to note that the judges of the Supreme Court split 5-4. Having agreed on the analytical framework, they didn't agree on whether or not it applied to the facts. So 5 judges said, and if you look at the words here, the second red bit, as a result of participating in this RFP, 5 judges said, actually all the judges said those were the key words, participating in the RFP, but 5 of them said, well, a process involving non-qualified bidders was not the process called for by, quote, this RFP. So the limitation of liability clause doesn't apply. It was outside the scope. Putting in a non-qualified bidder was not in the RFP. 4 judges said, well, participating in an RFP starts with submitting a proposal. And so this actually was something that was captured by the limitation of liability. And 4 judges said the limitation of liability clause should apply. So a complete split on the facts. But I'd suggest what's more important is the fact that the court focused on the words and the surrounding factual context, not the doctrine of fundamental breach. And I'd like to show you what the Supreme Court of Canada had to say about fundamental breach. And this is important because I mean it when I say it's dead. So these are the words of Justice Binney, who we all know has a special turn of phrase, where he talks about shutting the coffin on the jargon of fundamental breach. And to be completely clear, he uses strong words. He says that the court has no discretion, those second red words, no discretion, absent some special circumstances, to not follow a limitation of liability clause. In other words, for the commercial lawyers in the room, whatever it is you negotiate, it sticks in Canada, and that's different from other jurisdictions around the world, absent, and we'll get to it, some rather usually or not very usual circumstances. So what's the takeaway? Limitation of liabilities are enforceable, absent rare circumstances, and that means that it's worth spending time on the wording of those clauses when you're negotiating those deals, particularly in situations where risk control, which comes up in software deals, for example, or other kinds of technology deals all the time. You want to very carefully carve out what risks a party is accepting. Get the words right, because you're going to be stuck with the words in Canada. So the next limitation of liability case I want to talk about is the Weyerhaeuser case. It's a decision from a couple of years ago from the Ontario Court of Appeal. Though I'll warn you that leave to appeal to the Supreme Court of Canada was granted last October, although the case hasn't been heard yet. This is, I think at least it's funny. I mean, lawyers think it's funny. Normal people wouldn't, I suppose. But this was a case where the Ontario Ministry of Energy gave a direction to Weyerhaeuser to clean up a mercury waste disposal site. And that obviously was going to cost a lot of money to clean it up. But years earlier, in a settlement between previous owners of that same site and the Ontario government had given an indemnity with respect to certain kinds of claims or costs that could be incurred by the owner of the site. And this case was really about that indemnity that had been given by the Ontario government. So this is the indemnity. And again, I'm not going to read the whole thing to you, but the point is you'll see that it's quite a broad indemnity. It includes statutory or other claims. And also in the last red part deals with the presence of pollutants, so the mercury here. So it seems to cover the issue of what's going on, but Ontario said, well, wait a minute, this is an indemnity, it covers third-party claims. Your claim is based on what the Ministry of Environment did. The Ministry of Environment is Ontario. There's only one crown. And so it's not a third-party claim, it's a first-party claim, so the indemnity doesn't cover it. And did that based on what it said was the correct interpretation of the words. So just to pause on the facts for a moment, because interpretation is important, I thought I would give you one of the many cases that lay out how you interpret a clause in a contract. So everybody, I'm sure, knows this. I'm going to run through it very quickly. So we know the first point is you look at the language. Good news for the people who draft language for a living. We also read it as a whole. We try and give meaning to all of its parts. We read it in its ordinary and grammatical meaning. We also read it in context, right? We try and figure out what the purpose of the agreement is based on the surrounding context. And last, we of course, we try and avoid a commercially absurd result. And I can tell you, as a litigator, I have yet to come across a contract interpretation dispute that one side doesn't say the other side is promoting a commercially absurd result. It's the way it works out. But I really just want to focus for a minute on the third point, the Romanet 3, because one thing I draw to your attention is in Canada, considering factual matrix evidence is required in every single interpretive exercise. It's not like in the US, where the law generally is you look at factual matrix, they call it something else, where the provision's ambiguous, or what we used to do under the parole evidence rule, which still exists in Canada. When you interpret a clause, you have to look every time at factual matrix. Now, the truth is that sometimes it's helpful and sometimes it's not. For example, sometimes there really is no real factual matrix, but it always has to at least be considered. And here, in the Weyerhaeuser case, it's worth noting that the trial judge had started with the words and then looked at the underlying facts, and the Court of Appeal said that's okay. You have to start somewhere, and it's sort of logical to start with the words. Again, for commercial lawyers, you're probably saying few, because that's what you can control most of the time, not the underlying facts. But I do want to focus in, and if you'll forgive me a digression for a moment, to talk about the last sentence of number 3, that the factual matrix cannot include evidence about the subjective intention of the parties. That idea that subjective intent doesn't count seems to cause a lot of angst among business people. So I thought it's worth stopping on for a minute. And I'd like to look at it from a particular point of view, which is one of the kinds of evidence you often see of subjective intent. Sometimes it's the two business people. One says, I thought the contract meant A, and the other one says, I think it means B. What they have to say they thought they meant doesn't matter. But the thing that causes people trouble is when the negotiation evidence isn't admissible, or when you look at it, because you could have weeks or months or years sometimes of negotiation leading up to a contract. And so then the question is, well, what about all those documents, all the emails between the parties? Are those negotiation documents excluded as part of subjective intention? And the short answer to that is yes, they are excluded. And I'd like to look at a case from 2 months ago from Ontario, from the Court of Appeal, that's a good illustration of this point. So let's talk about the facts for a minute. Good Life, you probably all know, bought a business that owns some fitness centers in Windsor. And just to make this easier, the name of the business was called Lifestyle Family Fitness, and it was owned by a guy named Rocco Tullio. So Good Life went to buy the business and noticed that Mr. Tullio also owned some other property in the area. And before Good Life bought Lifestyle, the parties, including Mr. Tullio, had a discussion and some negotiations about whether Mr. Tullio would give a restrictive covenant on all his other properties that he wouldn't allow anybody to open a fitness center on those other properties too. At the end of the day, Mr. Tullio didn't give that covenant for the particular property that later ends up in dispute. But what he did do is enter into a right of first refusal for leasing. So Good Life had the option of leasing for itself if one of its competitors came around and said they wanted that other property. And Mr. Tullio gave a non-compete, a separate agreement actually, that had the words in it that he couldn't provide, quote, development services. So that's what they agreed to. So everybody probably can guess where we're going. Good Life buys the business. A competitor says, I'd like to take, rent the land or rent the property for a competitive fitness studio. Notice was given under the right of first refusal. Good Life didn't exercise it. Instead, they sued Tullio and said, by agreeing to lease to this competitor, you've breached your non-competition covenant. or your non-competition agreement, not covenant. Now, the court at first instance looked at all the negotiation documents, the long history, what everybody had said to each other, and how these different agreements, the covenant discussions, the right of first refusal, the comp, how they were all supposed to fit together during the negotiations, and concluded that Mr. Tullio was liable for having breached his obligations, sort of looking at it as a whole, taking account all the evidence. The Court of Appeal said it was an error to rely on the negotiations to interpret the agreements, and instead focused on the plain wording of the agreements, which in the case of the ROFR allowed the lease as long as Good Life had been given notice, and also said, well, listen, Mr. Tullio provided the regular services of a landlord. Those aren't development services within the meaning of the non-comp, so he's fine. The point here, I think, or what's important, is that the negotiations, at least the trial judge or the judge at first instance, thought they illuminated what the bargain was, the business bargain between the parties. But when the Court of Appeal excluded that evidence, it arrived at exactly the opposite conclusion. So this kind of thing matters and makes a difference. So you're the experts, but the lesson here, I'd suggest, is that if something's important, put it in the contract. Even if everybody looks like they're on the same page after months of negotiations, the court doesn't pay a lot of attention to what the parties wrote back and forth to each other unless they put it in the agreement that gets made. And, you know, we all tell our clients that, right? And all of them tell us the agreement's too long, right? So there's a balance, obviously, between the two. But this is an illustration that may help you when you're dealing with your clients about why an agreement that's printed only on two sides of the same piece of paper may not be the best idea if the deal is material. So let's go back to limitation of liability. So we talked about we're excluding fundamental breach. Turcon also tells us that now, absent fundamental breach, there are three things you have to do in order to decide whether a limitation of liability applies. And it's those on the screen. You interpret the contract, you look at whether it's unconscionable, and then you look at whether there's some overriding public policy concern that makes you override the limitation of liability. So I'd like to look at a relatively straightforward case that applied these three steps so you can see how it works in practice. So that case is a decision last year from Ontario, and it involved, it's a software case, I should tell you, where a company called MediaLinks contracted with UPS to do its shipping. And part of that arrangement is UPS provides its customer with software. The software is provided under a license. And one of the things this software was supposed to do is it had a built-in function where MediaLinks, the customer, could mark up each shipment by 0.7% profit. So the idea was is the software would track and include a small profit margin in every single shipment that took place, all based on the UPS software. Well, UPS did something during some custom development stage, and in error, not on purpose, but in error, turned off or somehow interfered with that function so that that 0.7% markup wasn't being computed, and no one noticed for 2 years. And so, you know, the company thought it was getting the profit. It turns out that it wasn't, and it decided to sue UPS, but there was a limitation of liability clause. And this is the clause. And the important point here is you'll see one of the things that gets excluded is lost profits. And of course, the shipping software, one of the things it was supposed to deliver was a feature that provided a profit to the user. So the question was, well, in not providing the very feature that the vendor was supposed to provide, was that excluded by this clause? And the court said yes. And it said yes based on reading these words because they're not qualified, right? It's in the list of things that are excluded among not just lost profits are actually a separately called out item, not qualified in any way in this particular wording. So the point here would be is this is what you want, negotiating, right? This is fine. If what you want is lost profits to be on the very thing you're buying, to actually be okay and not caught, one common way to do this, and we looked at this actually when we were here 2 years ago, we looked at the Atos and Sapient case. This is how they did it there. One of the ways to do it is you can say indirect damages are excluded, including lost profits, and the courts have said that means that the only type of lost profits that are excluded are the indirect kind, not the ones that directly flow from performance of the contract itself. So you can word around this. So really the point here is just to be conscious of it, that it depends which side you're trying to negotiate for. There's more than one way to look at this. Same case, the court also looked at the second branch of TURCON, which is unconscionability. And unconscionability is measured, according to the courts, at the time the contract is made, not later. And so you'll see here that the court essentially was saying, well, this doesn't look so bad. It doesn't exclude really offensive things like wrongful or intentional conduct, right? If it excluded that, maybe we'd be more upset. But, okay, this was a bargain. The lost profits from the software were excluded, and we can live with it. And interestingly enough, you'll see in the last red letters, the court mentions as a factor the uppercase letters. Now, to me, that seems very 20th century, but okay. We can live with that. The court also on unconscionability took a look at unequal bargaining power and said MediaLinks had no way of bargaining with UPS over the standard form contract. Like it didn't bargain over it and it couldn't, but it could have gone to FedEx. Like there were competitors in the marketplace. And so it found maybe there was unequal bargaining power if you look at it narrowly, but not really if you look at it that there are alternatives available in the marketplace that they could have gone to. So no unconscionability. The third point under TURCON is you look at public policy, and this was the argument that MediaLinks. They said, well, the contract, if you read it the way you're reading it, precludes the very thing I contracted for, that 7%. And it would be unfair as a matter of public policy to enforce the clause if it makes me lose the very thing or one of the things I bargained for. The court said, no, that's not right. That's what limitations of liability can be for. No problem. You should be more careful with the wording. In contrast, this wasn't present in the MediaLinks case. Fraud is a well-recognized public policy reason for not honoring a limitation of liability clause. You can't induce somebody to enter into a contract by fraud and then say, gotcha, the limitation of liability clause applies and my damages are excluded or minimized. And we saw that in the BDC software case I did a few years ago where the vendor was found to have committed fraud. There was a unique wrinkle there in the limitation of liability clause, but there the vendor was ordered to pay $49 million to its customer for having fraudulently made an RFP proposal. So this stuff matters in the real world. Now that case took 6 years or 7 years to go all the way through. But still, $49 million in the Canadian context is a decent sized number. The same three-part test we just looked at from TURCON, interpretation, unconscionability, public policy, also applies to entire agreement provisions. So it's worth looking at that because the courts look at an entire agreement provision as a form of limitation of liability. It puts them in the same category and treats them the same way. I don't want to spend a lot of time on this, but I would like to contrast for you two cases. One where the entire agreement clause was treated as no big deal and the court enforced it, and the other where the court said it was outrageous and refused to enforce it, so that you can see the difference. So the first case is the Manor Grade case. It's a real estate case. and but I have to tell you, the facts are such that this could have been a software development case. It happens to be about real estate, but it's exactly the same kind of thing we see all the time. So here, Manor-Great hired an architect to design some townhouses, and before the contract was signed, the architect, whose name was Kirkor, said, I can design this particular set of townhouses, so it'll cost you $130 a square foot to build them. So then Manor-Great entered into the contract, which had an entire agreement clause. Manor-Great started to try and build this and said, you know what, I can't build this project, as it turns out, for anything like $130 a square foot, and had to cut back on the project in a way that was very expensive to the developer. And so they sued for negligent misrepresentation, sued the architect about the representation about the $130. And the architect said, I've got an entire agreement clause. You can't point to things I said before we signed the agreement. And this was the clause. And most of you will look at this and say, boy, this is vanilla. Nothing really special about this. Very common wording. You see it on your screens. So what happened is the court looks at this and pulls some words from an earlier decision of the Court of Appeal in Ontario and says, well, what we have to do is lift and distill the parties' bargain from the muck of negotiations. We now know what the Court of Appeal thinks commercial lawyers do, right? They spend their time in the muck in the valley. Okay? I'm not sure that's the politest way to put it, but the Court of Appeal. And also points out that generally speaking, though you can change this by the wording, entire agreement clauses are retrospective. That is, they eliminate what came before the making of the contract. But again, there is a way to word it so you can make them prospective too. But this was a retrospective clause. And I can tell you this decision, the appeal from it was dismissed a few months ago. So that's an easy case. Now let's look at the one where the court went the other way. Now, for those of you who came into Toronto, you might have noticed that what used to be Trump Tower is across the street. A few years ago, maybe 2 years ago, the Court of Appeal made a ruling on the lawsuit by people who had invested in units, like bought apartments essentially, as part of the hotel, and sued the developer. And this is a case where leave was denied to the Supreme Court of Canada. So the case we're going to talk about is the final word from the Court of Appeal. So when these fights happened, the allegation of some of the investors was there were all these representations about how great these units would be, that people would stay in them all the time, and you'd make your money back in just in what effectively is rental or hotel room rates. And those statements turned out to be generous. They turned out to be inaccurate. Okay? And so there was several lawsuits over this. But there was an entire agreement clause in the agreement with the several actually entire agreement clause in the agreement with the investors, and that dealt with prior representations. And this was the clause. And you'll see that it says that there's essentially they agree that there are no representations. So period, end of story. Now the motions judge who heard the case in the first place excluded the misrepresentation claims from the lawsuit because they said this clause and some others precluded them. Right? It enforced this limitation on liability applying the three-part Turcon analysis. The Court of Appeal disagreed and found this clause was unconscionable. And I'd like to show you the Court of Appeal's words. First of all, they say this entire agreement clause was a trap. Now, that's what they said was a trap. Okay? So this was a trap. These people had minimal investing experience, knew little or nothing, hadn't consulted with a lawyer. And keep in mind, this isn't a consumer contract. These are investors, right? We know there's a whole different set of rules for what you have to do with consumers. These are investors. A little bit more what the Court of Appeal had to say. It said, well, the clause was well hidden in a 17-page long agreement. I don't know, does anybody think a 17-page long agreement's long? It said nothing distinguished. So there's no bolding, no highlighting, no capital letters for this clause, and that the salesperson never reviewed this particular clause with the investors. So the question that comes to my mind is if you were acting for the developer of the property and you wanted to sell units to investors and you wanted them to be bound by the limitation of liability clause, what would you do? So we can talk about this if people have ideas, but I guess you can put it in bold. I guess you could put it in capital letters. I guess you can make sure that the investor signed the clause or initialed it. I suppose you could require ILA, though you have to start wondering for transactions that may not be huge value, if that makes sense. And I suppose you could hire somebody to take the investor through every clause and explain it to them and explain their implications. But you can think about whether there are other things you can do if you were on the developer side that would bind the investors. So it's interesting. I don't think I've ever been to a session or a CLE session that talked about entire investment or entire agreement clauses. Like that probably is at the bottom generally of the things that nobody ever looks at again when they're doing their standard clauses, despite it clearly, for those of you who are litigators, it's one of the first things you look at when you have a dispute on a contract, along with dispute resolution, limitation of liability, a few other things. It's an important clause. But it drives home to me why today we decided to stay away from the cutting edge topics and try and focus on these things. And but it's worth noting, if you want to know about all the cutting edge topics, the TCLG, Cantech, like they put on great events about all kinds of things that are on the cutting edge. And so does iTech Law. In fact, iTech Law is running a conference in May in Boston. I'm on the executive committee of iTech Law, so I can let you in on the secret that it's going to be great. Okay, so I can encourage you all to attend. Boston's not far away. It's an easy one to get to. And there are people from all over the world there. And if you want to know more, just ask. I'm happy to talk about it. Now, I'm going to switch topics for a minute. But before I do go to talk about breach of contract, breach of confidence, we're sort of leaving the contractual part of this. Does anybody have any questions or comments? Why don't we start in the far end and we'll move back. Sure, either way.
On the limitation of liability, let's take Ontario for now. Is there a distinction between negligence and gross negligence?
So in Canada, I don't know of any. As a matter of law, if you put it in your contract, the court seemed to look at contextual factors. So if you have one clause that says negligence and one says gross negligence, they don't say, I know what negligence means and I know what gross negligence means. They try and figure out what you meant, like if you meant one to be at a higher standard. But if you just say gross negligence, as I understand the situation, it has no intrinsic meaning. There's no different test under the law than negligence. But we see it in the US all the time because, of course, the law is different down there on that point. There was another question sort of in the back corner somewhere.
I actually have two questions, if that's okay. The first one is, as a customer who deals with a lot of US suppliers who generally want contracts for their provision of products or services to be governed by, let's say, New York law or some other US law, we've actually generally taken the position that we prefer Ontario law or Canadian law, but I wonder, based on your comments that the doctrine of fundamental breach still exists in the US and doesn't in Canada, whether in fact that might be a factor to consider, it may be advantageous to have US law apply rather than Canadian law.
So that's a very good question. First of all, they don't call it fundamental breach there, but I'm told by my colleagues in the US, and I keep bumping into this, that they are more suspicious, if I can put it this way, that courts will always enforce limitation of liability clauses, and there are state by state, often there are different words they use, but the point is some kinds of breaches prevent reliance on a limitation of liability. So I think the answer to that question is that would be one factor in choosing the law you'd like to apply to your contract. There could be a multitude of others, right? There could be IP issues that are important that you'd rather be in Texas, right? There could be other things you'd rather be north of the border. there really isn't any substitute for looking at the two alternatives and trying to figure out which one is overall better for you, because sometimes you'll have indicators that point in different directions. So, but clearly that would be one of them.
The other question I have is, I've always assumed that it was a principle, I guess, of Canadian law that courts will construe limitations of liability narrowly and only apply them where it's very clear from the language used that the limitations meant to apply to a particular circumstance. After hearing everything you've said, I wonder whether that assumption is still a valid one.
I'm trying to think of a politer way to say no. It doesn't work like that anymore. And it's been pretty clear for about 10 years now that you use that three-part test. That is the test. And by far the most important part in practice is the interpretive part. And we have largely foregone in Canada most of those Latin maxims some of us learned in law schools. We still have contra preferentum that still exists, but most of the time to interpret a clause, you look at the words, you look at them in context, read them as a whole, et cetera. Those four parts that I showed you earlier, and there are two relatively recent decisions of the Supreme Court of Canada that make that very clear. It's, this is the test now. Any other contract questions? Okay, so let's talk about breach of confidence. So I'm not going to talk about contractual breaches. That is, you have a contractual obligation of confidentiality. Candidly, that's the easy one because the contract usually says what's confidential and tells you what's a breach. So the law is you follow whatever people agree to in the contract. It's not, doesn't sort of rise to any special level, though there are some wrinkles on damages, on how you figure out the damages from that kind of thing. But I do want to talk for a minute about something that seems to come up less often, which is the restitutionary cause of action, breach of confidence. So that's the cause of action that lies in an overlapping way in both the common law and equity. And again, I'm not going to read it to you, but this is a helpful formulation from a recent case in Alberta. There are lots of cases that state it, where the requirements are, it has to be confidential, which, by the way, is different from a contract, right? You can actually say in a contract something is confidential, but really isn't, and everybody will pretend it's confidential and act on it that way. But under the breach of confidence cause of action, it actually has to be confidential, communicated in confidence, and it has to have been misused by the party to whom it was communicated to the detriment of the person who provided the information. And it's that last one that often gets bumped into in the technology context. So I'd like to talk about a case that illustrates those principles in action. It's a couple of years old from British Columbia, the Tucci and People's Trust case. This was a class action certification case. Long decision, law, like a kitchen sink of causes of action. I'm only going to focus on one of them. But the idea is the defendant here, People's Trust, was a trust company, and it had savings accounts, it had mortgages, it offered credit cards. And so it had lots of personal information coming in through its portal and in its databases. And cyber criminals gained access to that data and used it for phishing with a PH, so attempts at identity theft. And as an aside, the Privacy Commissioner said that the controls People's Trust had used weren't adequate. Okay? And there are lots, sort of, as I say, many causes of action about that. But one of them, the idea was an allegation for breach of confidence that People's hadn't adequately secured the data that it had in its possession. And People's response was to say, well, we didn't misuse anything. We had no intention to use the data for anything but the very purposes we've gathered it. The misuse is actually by the cyber criminals. And under breach of confidence, we cannot have been said to intentionally arrange things so as to be victimized by the criminals. And the court, with a trial level court, agreed with that submission and struck the breach of confidence claim, said it's not part of the lawsuit. So again, the lesson here is we have to be careful to focus on, in those kind of situations, who's the victim, who did something wrong, which, by the way, there not being a breach of confidence claim doesn't mean there's no claim against Peoples. It's just it doesn't lie is a breach of confidence claim. Okay, so let's switch topics again to talk about a little bit about arbitration. From a particular point of view, I'm going to try and focus on it from the people who prepare the contracts that arbitration clauses go in, as opposed to how to do an arbitration. And I have to say, I've now find these cases much more interesting since I started being asked to act as an arbitrator and mediator from time to time. It's kind of fun, actually, to help people, like two sets of parties or more, settle their disputes instead of just acting as an advocate for one side. So that has brought some of these things home to me when I do things that are not, the advocacy of my day job. So the first case I want to talk about is a easy case. It's the Belnor Engineering case. It was decided about 2 months ago in Ontario, and it's a sales commission dispute. And there was an arbitration clause in the contract, the one that's on the screen on your left, and you can see that it's a modified version of the American Arbitration Association clause. And the key bit is you'll see on the right, the AAA says, shall be settled by arbitration. And on the one on the left just says, shall be settled, and then in accordance with the arbitration rules. And the defendant said, this is not an arbitration clause, because it doesn't say settled by arbitration. And the court had no problem saying, no, that's an arbitration clause. The point of bringing this to you is not anything more than saying, these parties modified a standard clause, presumably because they thought it was a good idea, probably not realizing that it would cause an extra step in their litigation or in their fight. And sometimes trying to do the new thing can have consequences that you didn't intend. So taking out those words or allowing the other side to take out those words caused a bump in a road that otherwise maybe didn't have to be there. Okay, let's talk about the next hiccup. This is a case involving the city of Edmonton, again, 2 months ago. Here, a contractor was supposed to drill a tunnel. The tunnel actually partly collapsed, so there was no tunnel. And the allegation is that the party acted in breach of the contract. The contractor breached the contract and was negligent. So you've got a negligence and a contract claim. And so the court looked at this dispute resolution clause and said, okay, it's disputes under the contract that have to go to arbitration. And that language, by the way, disputes under the contract, is not as broad as some of the other language we typically see. And so the court seemed to believe this was a narrow clause, which suggests, of course, what we all know, which is wording matters. It's not irrelevant. It happened in this case that all the torts were actually pleaded to arise out of duties under the contract. So the court said they overlapped, so there was no problem because everything that was a tort was also a breach of contract. And so there turned out not to be any problem, but you can imagine in other fact situations it could be a problem. And just to drive this point home, I thought I'd bring together 4 standard arbitration clauses. One from the International Center for Dispute Resolution. I probably shouldn't have put it first since I'm on their roster, but whatever. So it's in the top corner. You'll see they don't just have arising, but they also have relating to this contract, which the courts have said are broader words. The ADR Institute talks about arising or in connection, and then has some more words, again broader. The ICC talks about arising out of or in connection. And the London Court of International Arbitration, again, uses arising or in connection and then goes on to even deal with existence, validity, and termination. The point is, these are broader words. And I wouldn't suggest that you choose your arbitral institution based just on their standard clause. There's way more to it, and it's a lot more complicated. But the point here is that words matter, and you have choices, and you don't have to invent things from scratch in this area. There are things you can draw on that have a long history. Okay, one more arbitration case. Some of you may have seen this. This happened earlier this year. It's a decision of the Court of Appeal involving Uber, in particular Uber Eats. And so there was a class action by the Uber drivers against Uber. And Uber drivers have a standard form contract, as you can imagine, with Uber. They don't get to negotiate one at a time with Uber. And there was an arbitration clause in that contract that quite long, but I want to tell you two features that mattered. One is it required arbitration by the ICC. And one of the features of the ICC is they require quite a large upfront deposit in order to engage in an arbitration process. So some money up front. And also this contract called for arbitration in Amsterdam, despite the drivers being in Ontario. And the court found that this clause, this requirement to arbitrate, was unconscionable. Not as a matter of interpretation. They actually found it was unconscionable because it required individuals to incur large upfront expenses and disproportionate expenses because of the ICC and the venue being in Amsterdam. And there was also no evidence of the drivers having any lawyers, and there clearly is an inequality of bargaining power. Though if you contrast that to the FedEx, the UPS FedEx, now that we have Lyft, maybe the evidence would be different, right? Maybe drivers can go drive somewhere else, or taxi companies. So I wonder, query how those fit together. But one of the implications of this is this clause didn't have to be considered under the Arbitration Act because the court said it's not an arbitration clause. And under the Arbitration Act, it's usually the arbitrator that decides whether he or she has jurisdiction. This wasn't. It was determined by the court in the first place. So what's the takeaway? It probably is if you're going to have a standard form arbitration agreement, it probably shouldn't impose a kind of arbitration or details of arbitration that are effectively a barrier or a significant difficulty to actually getting to arbitration. Like essentially don't go too far. There's a question over here. Sorry, I can't hear you.
What was the large upfront amount?
So I don't know uphand, but the ICC is a percentage of the total claim. So if you add up all the Uber drivers, the idea would be that it's a relatively large amount. And the different arbitral institutions have different ways of dealing with this. They all ask for money up front. The question is it a fixed fee and you pay a little more later, or is it a big amount as a percentage of the total value of the claim? The more you claim generally at the ICC, the more you have to pay. Okay, last topic. Has anybody ever been asked the question, if I win or lose the lawsuit, depending what side you're on, how much money do I get or I have to pay? Right? People don't just want to know about liability, and that's not just from litigators. They often ask the first people that they talk to, their regular lawyers who are their trusted confidants. They ask you, well, how much am I going to have to pay? Now, 2 years ago, we looked at the Atos and Sapien case when it was just at the trial level. We now have a Court of Appeal decision. That case deals extensively with how you deal with damages in a breach of contract situation. I'm not going to take the time here to go through the whole thing. It's worth, I think, for the technology bar to read both the trial and the appeal Atos decisions. They're long, but they've got lots of nuggets in there that are worth looking about. And I can tell you that a few days ago, the Supreme Court of Canada dismissed the motion for leave to appeal from the Atos case. So the Court of Appeal decision is now final. But I do want to cover one little piece, which I think is interesting. It doesn't, again, come up very often. Atos at trial was awarded about $6.3 million. On appeal, Atos at trial got 6.3. Sapien on appeal said that should be reduced to $1.5 million. And the reason they said that is they said, well, we know that for a breach of contract, you get compensation, right? Law School 101 contracts. And the way we measure damages for breach of contract is expectation damages. That is, you get the amount that would put you in the position had the wrongdoer performed the contract. Okay, so expectation damages. But there's a little wrinkle to how you figure that out that came up in this case that I want to deal with today. And that's the minimum performance principle, which is this. This is the law on it. in cases where a defaulting party has an alternative mode of performing the contract, you look at the least burdensome way when you're measuring the damages. So let's take a look at how it gets applied in the Atos case. So under the contract, Sapient had a right to terminate for cause, which it did. Its letter terminated for cause. But the contract also allowed for termination for convenience, which wasn't done. But Sapient, the court found, could have terminated for convenience. And in the termination for convenience provision, there was a formula that provided what you get if you terminate for convenience. And to make a long story short, the convenience number was way, way smaller than the termination for cause number if you calculated it on that basis. So the court found that Sapient could have terminated for convenience and cause at the same time, that was possible. And so although the contract was terminated for cause, under this minimum performance provision, they instead calculated the damages on the termination for convenience provision. So terminate for cause, get termination for convenience. So really the lesson here is when your clients ask you, how much are we going to get? The answer is, let me think about it. That's complicated. Because there are these wrinkles, this is one, for even in contract cases, which as things go are one of the more straightforward ways often of figuring out damages. Even in these cases, there are these wrinkles that may not be intuitive to business people. Are there any questions on this last point? Okay, if not, I just want to thank, sorry, Rob.
Yeah, hi. This is really interesting and troubling all at the same time. I mean, often in larger technology contracts, obviously the termination for convenience numbers are based on, some sort of amortization schedule on what it would take the vendor to pay off its expected investments or what have you. In a termination for convenience situation where there are no fees available, would this play out the same way? Do you know what I mean?
Yeah, so it's all about the facts. Right, so I've had cases where theoretically you have to worry about this particular wrinkle, but as a practical matter, either the calculation works out exactly the same because there's no formula, or when you apply the formula, you get to the same answer, or the answer is zero. Like, unfortunately, Rod, there's no, I wish I could give you a sort of a yes or no, like we tried the other time, but
that's what I was here for.
Yeah. Yeah, well, enjoy the cookies. That's the best I can do. Okay. Sorry, there's a question here.
Use a termination for convenience clause to cap your liability?
Okay, so the question is, can you effectively use a termination for convenience clause to effectively cap your liability? I suppose if you're in a Machiavellian frame of mind and the other side doesn't catch it, because you can draft to solve this problem, right? This occurred because this is not what people were thinking of at the time. But if you were Machiavellian and it slipped through, this would be one way of doing it, though you're betting that the facts at the time of the breach will work out in your favor. So my suggestion would not be to leave it to chance, but to do what you can on the express limitation language. But if you find yourself on the right side of this issue, you've got an extra arrow in your quiver, or if you're on the other side, an extra risk that may induce you to settle.
Just a cautionary note, I've heard from a judge, quite famous in this province, that if you're using termination for cause to avoid paying what you should pay, they'll ignore it completely and look at convenience.
It all turns on the facts, because the question is should you be paying? Most termination for cause provisions apply when, of course, there's cause, and through negotiations, cause is usually bad things. So I suppose you're right. If the person really didn't had cause or was marginal, judges typically don't like to punish people for behavior they don't think is bad, and they don't like to arrive at unjust results, but they do enforce contracts. that are clearly drafted. Okay, so I'm delighted to take more questions afterwards if you want to come up and talk, but while Chris is coming up, let me just please thank you. I have to say the attendance and your questions have been and attention have been overwhelming, which I really appreciate. And I also wanted to thank Sandra and her team who did an awesome job, and all the people from iTech Law that arranged the video connection. It's not often we get to do this with this camera sitting in front of me, with 200 of my best friends. And I just want to thank you again, and I hope we get to do this again in a year or two, though I'd encourage you in the meantime, if there are bread and butter subjects you want to talk about next time, like just email me, because you know better than I do what are the things that are troubling your clients in the valley or the muck, depending on your point of view. Anyways, thank you.
Well, and Peter, thank you to you for doing this. And on behalf of Peter and Goodmans, Cantech, TCLG, and iTech Law, we want to thank all of you for taking the time to come and join us both in person and on the web. It's great to see such a large turnout for this event. And as Peter said, the information for CPD instructions, as well as the case hyperlinks, will be posted and sent out in due course. And a lot of the slides and information will be put on the various websites. So if you get a chance or you want to review, you want to look at any of that, please feel free to look at Cantech or iTech Law or Goodmans. I also, my name is Chris McCooch. I'm the new Executive Director of the Canadian Technology Law Association. And just want to take a minute to add, not only is the iTech Law event, the conference in Boston in May, we also have our conference here in Toronto in May. So feel free to go to both. Feel free to stay at ours. Go to Peter's as well. But yes, so there's a lot of good events going on. I hope you guys take advantage of them. If you're not members of these groups, please look into them. There's some really good programming going on, really good information that's available to you, as well as great networking opportunities. And finally, on behalf of everyone here and watching on the web, I just want to say again, thank you to Goodmans and to Peter, and especially to Sandra for putting together a great event, and great to see all of you. And Peter, we will not wait 2 years to do this again.
Okay. Thank you.
Under my feet, I feel the sky falling down. I feel my heart start